Richard, I guess before we start, this case covers so many issues and so many juicy points for us SMSF practitioners. But it's called Re Narumon because it wasn't contested by another party. Just wondering, what does that mean as far as your job as counsel for the case, and does it affect the weight of the decision at all?
Yeah, it's an interesting point, Kieran. The case is reported as Re Narumon Pty Ltd. It was an application by the corporate trustee of the self-managed super fund. In fact, counsel's job is more difficult when there's no opponent arguing a different course, because you have a duty to the court to make sure that the court hears both sides of the story. So it actually led to a lot more work and more detailed submissions than perhaps you would have seen if it had been a contested matter. There was one other party that you see mentioned on the judgment, the litigation guardian for the minor child. We'll see who that is in a moment. But they didn't make any submissions. So whilst the judgment says that it proceeded on the basis of comprehensive written submissions, there was a hearing, and it certainly doesn't detract from the principles in the case.
All right, if we could get into the facts of the case, I guess, if we could have that slide. And so this was a case that had it all, and so we'll talk about all the issues, the main issues of this case. But this was a case where Mr. Giles was 80 years old, and he'd been married to his second wife, Mrs. Giles, Narumon Giles, for almost 19 years. And they had one son together, as Richard mentioned before, Nicholas. And Nicholas was 16, hence he wasn't 18, needed a litigation guardian to represent his interests. Now, Mr. Giles, he also had children from a prior relationship, Patricia, Gregory, Anthony and Kelly, all adult children. And it was a 19-year marriage, so that was a relationship that had ended a while ago. And so the assets of Mr. Giles were predominantly his superannuation. So that was $3 million in a lifetime complying reversionary pension, and $1 million being in his accumulation account. So very significant assets, for his member benefits inside that fund. Whereas his actual estate was quite minimal. It was only $200,000. Now, Mr. Giles had Parkinson's disease, and late in 2013, I think November 2013, he was diagnosed by a geriatrician as having dementia and being totally incapable of making decisions for himself. And so then a few years later, he died in 14 June 2017. And so we were left with a situation where one of the children, Patricia, was not comfortable with the estate, and so had challenged Mr. Giles' will there, and it was quite a small amount. So obviously all of the children from the former relationship were quite interested in what would happen with Mr. Giles' superannuation. And as we'll talk about soon, there was lots of kind of areas that were uncertain with respect to the history of the fund that have been around since before 2000, and some of the documentation inside of that fund. And I'll just pass on to Richard now. Richard, what were the key issues out of all of this treasure trove of issues that were discussed in this, that were determined in this case?
There's a lot to unpack. I should perhaps just say at the outset that given that I've acted in the case, I can obviously only discuss things that were dealt with in open court during the judgment. But I think when you look at the judgment, it divides probably into 6 different areas which are key takeaways.
We have that slide, please.
The first one is to deal with deeds of ratification and the extent to which past acts can be ratified. You've heard a lot about deeds of ratification, I'm sure, but we're going to look in a moment at what they actually do. The second issue is to do with missing pension documents. Thirdly, the key question in this case: can a nomination, a binding death benefit nomination, be made or extended by an enduring attorney on behalf of their principal, the member? The judgment also looked at conflicts of interest and how that interacts with that question of making a nomination or extending a nomination. And a very interesting aspect was also partial invalidity. What happens if you've got a nomination and some of the people nominated may be ineligible. Does the whole thing fail? And lastly, there was some technical clarification given, which is useful for practitioners in this area, around how the legislation works for nominations, specifically in the area of SMSFs. So they're really the 6 issues, Kieran. It's a fairly long judgment. Now, looking at the first one, if the fund documentation isn't properly executed, how as a practitioner do you go about advising clients on what to do on that?
Thanks, Richard. Can we kill this one? So, I guess, yeah, the very first step in determining any trustee action really is very much so in determining whether a binding death benefit nomination is applicable or not, is determining what is the deed that is the applicable deed that governs the trust. And so this particular superannuation fund had been around since before the 2000s. So as you can imagine, there's been so many changes in the super law, and the deeds had been updated so many times since then. And in these death benefit disputes, what happens is you've got to figure out, well, is the latest deed applicable? And so lawyers who challenge death benefits, they engage people like me and Richard to look through all of that chain of deeds and see if there's any chink in the chain. They can challenge any item, any change of trustee, any deed, and therefore, if the actual deed that governs the fund is an older deed, an out-of-date deed, that might not have those death benefit provisions in it that make the death benefit enforceable. So in this case, the applicable deeds that we were looking at were a deed of variation in 2004, a deed of variation in 2007, because there was those massive superannuation changes, the simpler super changes in 2007, and also then a deed of variation and ratification in 2014.
So what is ratification? Does it work?
So in this instance, the reason why they needed the ratification was because the 2004 deed, the accountant looking after the fund, he noticed that the execution by the trustee hadn't been executed in accordance with the formal requirements of section 127, and the parties hadn't executed that deed correctly. And so a lot of lawyers out there, Richard, consider that, okay, well, any defect like that execution defect, well, that can be remedied by a deed of ratification to say, hey, despite the fact that we didn't execute that 2007 deed correctly, we'll ratify that execution and then we'll move on as normal. And in fact, when you do a limited recourse borrowing arrangement, the banks go through every deed and get, fix up all the past executions, etc. And a lot of the time, they want them to be ratified, and despite the mistake, they want that deed to be ratified. But the actuality of it is that 2007 deed, because it wasn't executed in accordance with the requirements to execute a deed, it wasn't effective as a deed at all. And so it sounds pretty harsh. You had the trustee executing the deed and, presuming and acting as if that was the deed, but it wasn't. So the 2004 deed was still the applicable deed. And then came along in 2014 to update the deed terms, and this mistake was noticed, and so the 2007 deed was purported to be ratified and also varied up to the modern deed terms, the 2014 deed terms, with those good death benefit provisions and those good provisions in it. And so Justice Baskell in that case agreed with Richard's submissions that ratification doesn't cure it. You can't ratify a defective execution. Fortunately in this case though, the deed was drafted widely enough that it still had the effect of varying that old 2004 deed and updating it to the 2014 deed terms. So we still got the right result in the end, but it's a really important note for practitioners that we can't just go ratifying deeds and making them good. And Richard, you pointed out before that it's different than a contract. So in a contract, if someone acts without authority, you can later authorise them to have acted on your behalf, providing you ratify that. And so that's not affecting third parties. But when you're talking about trust deeds, well, you're talking about if you're making anything retrospective, you're retrospectively ratifying what happened and trying to rewrite history, so to speak, that could affect third parties, beneficiaries, minor beneficiaries and other people. And the court in that case, Davis and the Federal Commissioner of Taxation, was it? That's the authority, for that point. So
it's useful to see it set out, isn't it, in the Queensland judgment, because I think we perhaps have a false sense of security around ratification. People talk about let's do a deed of ratification, but I think we really have to be careful about distinguishing, as you say, between contracts on the one hand and trusts on the other. So Justice Bosco was very clear that it couldn't fix the problem. It wasn't a magic wand.
So I think, as practitioners, we've all got to be really careful in that space as solicitors and really look at our practice and see if there's another way that we could do that, whether sometimes you can still, I believe, depending on the terms of the deed, you can sign it at one point, but you can say it has effect in the past. Providing the deed allows that, that can still be, an effective way to get around the problem. But sometimes, if it hasn't been executed properly at all, well, you can only fix it from the date that the parties actually, fix this up. That's the date when it happened. And so that was one problem, is identifying the deed in itself. And then you've also got to look, well, it's not just the governing rules that apply. With the self-managed super fund, it's your minutes of your trustee, your administration of that fund, including your pension documents and your binding death benefit documents, etc. And whether those can get lost or whether they're not kept up in the as good as they should be. They're not kept up to order. Richard, what were the circumstances in this case?
Well, it's a fairly significant problem in this case because, as you've said, there's a fair amount of money sitting in the lifetime complying pension, but the documents couldn't be found. So there were no documents, no original documents to show the establishment of that lifetime complying pension, and unfortunately there weren't any copies either. Kieran, it was a surprise to me moving to Australia a few years ago from the other side of the pond to see that there isn't an equivalent of the sort of trust management industry that you see in the UK and in the Channel Islands, where many trusts, mum and dad trusts, are actually managed by professionals, and they're used to dealing with keeping documents, keeping records, keeping accounts.
Well, Richard, in the court matters I've been involved in, I think a lot of people have got a misconception that trustees of self-managed super funds, because they're the members of it too, don't have the same duties as a trustee of a larger public offer fund. But the court finds differently there, don't they?
They do. I mean, the responsibilities of trustees fully apply. And you see, in this case, it wasn't just the problem of the missing documents of the lifetime complying pension, but of course, on the facts, Mr. Giles was deceased. What needed to be really established was that his wife was entitled to the reversionary pension, and the documents for that were missing. They couldn't find the original nomination for that, nor any copy of it. But all was not lost, because there was a way to deal with this, and the way that it was dealt with was by making very extensive inquiries, and those inquiries revealed that there was correspondence around the time that the pension had been established with professional advisors and also with an actuary. And it was very clear from that correspondence that the basis on which a pension had been established and started to be paid was that it would be reversionary to Mrs. Giles, because of course the calculation that the actuary would have needed to perform would have been radically different had it not been a reversionary pension. So there were clues, and the clues, when they were all assembled together, such as the details of the searches that had been made and a statement from the actuary, they all added up to really give the court sufficient comfort, at least on a balance of probabilities, that the correct power in the deed had been exercised and that the pension had come into existence, and furthermore it hadn't been revoked before Mr. Giles died.
Richard, in the matters I've been involved in, a lot have settled, but I've seen that time and time again, especially with those older pensions before 2007. You're exactly right, I don't think it was common practice for those pension commencement documents to be properly minuted. And so, they were quite lucky in this case, I think, that they had that evidence and that it only could have been a reversionary pension because of those calculations. But the case might have been different with, if it was an account-based pension, because those calculations don't come into it at all, do they?
That could possibly be right. I mean, these are very much cases on their facts. Anything to do with evidence, it's a case of marshalling as much as you can to try and show that the onus has been met.
And
I was just going to say, Kieran, this all really led on to the major issue in this case, which is the one that's attracted a lot of interest. And people say, "Oh, Re Narumon, it means that an attorney can now make a binding nomination on behalf of their principal." That's not really quite what the case said, is it?
No. And Erin, if you could just bring up that slide that I skipped through before, and then we'll go to the one after that. And so I'll just refresh everyone of what the state of play with this was. As you'll recall, Mr. Giles had lost capacity. Now, he had done a binding nomination in 5 June 2013 before he'd lost that capacity, where he was giving the entire amount of his super benefits to his wife, Mrs. Giles, his son, Nicholas, and then 5% to his, I think it was his sister, Mrs. Keenan, who was also the executor of his estate. Now, us SMSF practitioners know that it wouldn't have been effective giving that nomination to Mrs. Keenan because she wasn't in that range of death benefit dependents, being a spouse, child, legal personal representative, or a dependent. Now, with this nomination, it actually expressly said that it lapsed in 3 years. Another round of nominations was done before this nomination lapsed, and that included a document that was entitled Extension of the June 2013 nomination, and also a fresh binding death benefit nomination, which remedied that issue of 5% going to a person who wasn't a death benefit dependent. So making it clear that it was 50% to Mrs. Giles and 50% to his son. And so that brings us to this case is, well, was an attorney authorised to actually sign an extension on behalf of a member, and was an attorney authorised to make that new nomination with that slight change to it? And if we could just go to the next slide. This one, yeah. And so if we're having a look at whether an attorney is authorised to amend an existing nomination, make a nomination or revoke a nomination, we've got to look at a few different documents and a few different legislative authorities. So first of all, the deed itself. So in this case, Re Narumon, the deed actually expressly permitted a member to act by its attorney in any matter concerning the deed. So any matter, any power a member had could be enacted by a power of attorney. So it had express authority. It was silent, specifically with respect to binding death benefit nomination, but that cover-all clause in the deed covered it. Also got to check that the deed doesn't specifically prohibit an attorney acting on a member's behalf. Then you've got to have a look at those provisions in the deed about binding nominations, that there's no prohibition in the actual provisions of that clause prohibiting an attorney from changing or revoking a nomination. Have a look at the form of the nomination. So sometimes the nomination itself will allow, in its terms, an attorney to change it, but at least can't disallow it. Then we look at the SIS Act, which is the act that governs all superannuation funds, a regulatory act. And does it contain any guidance on this matter? And well, the answer is no. It's got some requirements for public offer funds, for APRA-regulated funds, as to what form that nomination might take. But it's silent with respect to whether whether an attorney can amend a principal's nomination. And so then we're looking at the Power of Attorney Act. And so here I'm specifically focusing on the Queensland Power of Attorney Act. That's where the decision was. Each act's a little bit different, but they're largely the same, I believe, in the different states. They've all got their own peculiarities. And in this act, so we have a look, well, what decisions is an attorney prohibited from making? And those decisions include, those kind of decisions on behalf of the principal include making a will or a testamentary act for that principal, marrying the principal. What's another one?
There's a whole range, and I think the difficulty for us is that it's all spelt out, isn't it, in definitions that sit in those schedules at the back of the Powers of Attorney Act. And we were helped a bit here because very recently there was a Queensland Court of Appeal case, Re Tracy, which looked at exactly this issue but in a different context. And the question for the Court of Appeal was, does the fact that those definitions appear in the back of the Act mean that they're prescriptive? And the court found that the Act shouldn't be read in that way because a more liberal construction was warranted. It was all to do with the application of the rule of Saunders and Vautier in that case, so nothing to do with what we're looking at today. But it paved the way for the argument that although we don't see in those schedules any reference to an attorney having a power to make or change a binding nomination, it can actually fit within the definition of a financial or legal matter there.
And that's because although when you first think about it, it seems like it's like a testamentary act, it's like a will, there's several cases that have gone through that and they've said, well, it's not. It's a power under a deed, which is an inter vivas deed, which governs, the payment of benefits. So it's an act you do now, and it's quite clear that it's not a testamentary act. So I guess that starting point is, providing the documentation doesn't prohibit it, the starting point is, well, yes, an attorney should be able to make or amend a nomination. But the complication is, in these self-managed super funds especially, is everyone's related to each other, and often that attorney's a spouse or a family member who might benefit from making or changing that nomination, which is the case with this, because Mrs. Giles stood to benefit from any renewing or making of a binding nomination, as did her son Nicholas. And
but there's no suggestion they've done anything improper, of course.
Yeah.
This was just a legal analysis of how the law relating to conflicts applies.
And so just to clarify, this power of attorney that they signed, it was just a general power of attorney for financial matters, an enduring power of attorney, and it commenced on Mr. Giles' incapacity, but it didn't contain specific authority to allow a conflict transaction. So what were the consequences of that?
Yeah, that's exactly right. It's a good point, because we hear many practitioners nowadays advising their clients to include a general conflict authorisation clause. But if you think about how that applies in this scenario, Kieran, that's actually fairly dangerous. You've got to be really sure that that's what the client wants, because as we'll see in a moment, this really opens up the field for what an attorney can potentially do, acting as attorney under the power. There's some really useful analysis in this case for practitioners, and it really comes from a case that I cited from New South Wales called Riley and Riley. It's a decision of the probate judge there, Justice Lindsay. Some of you may know that Justice Lindsay is an avid legal historian, and he has a particular interest as the protective list judge in matters dealing with persons who lack capacity. And the Riley and Riley case is very useful authority, and it's been cited with approval, you'll see in Re Narumon by Justice Boskill. I'll just read you briefly what she says. And it's quoting from Justice Lindsay. Where a fiduciary, such as an agent, and remember that although a power of attorney is a creation of statute, many of the similar principles of a fiduciary nature apply. So where a fiduciary exercises a power which results in his or her obtaining some incidental benefit, there may be nothing per se improper with that, provided that the benefit is, in the circumstances, an inevitable consequence of them properly exercising the power. So you see there, Kieran, the spotlight's really on the proper exercise of the power. That's the first thing you've got to look at. And if the benefit flows on from that just incidentally, then the court may be prepared to find that it's not an actual conflict.
Well, that's interesting, because my first thoughts when I saw the circumstances of the case was, well, if there was no conflict transaction permitted in the power of attorney document, because the attorney stood to benefit, then therefore any act by that attorney would automatically be void. But I think Justice Baskell had the same thoughts to start off with, but then on further analysis, by your submissions, developed her opinion.
Well, that's right, and we did test the limits in the submissions, and you'll see in the judgment, Her Honour didn't agree with all of the propositions that were put forward, and you'll see that Her Honour describes her own decision as being conservative in this area. I think the point to note here was that the evidence was really important, because we have to look at the context, and it was inescapable here that Mr Giles had made binding nominations in the past. He'd made 5 of them. So that gave a very good clue to the court that he really did want to have the autonomy, notwithstanding that he lost capacity, to be in a position to exercise this. So if he had capacity, this is something that he would have wanted to do. It was likely found. So the making of the 2016 extension was found to be consistent with the exercise of that autonomy, because it enabled his wishes really to be upheld rather than defeated.
So, Richard, correct me if I'm wrong, but that means because the members' interests coincided with what the attorney did, even though there was no conflict clause, because they coincided, it didn't matter that the attorney got some kind of coincidental or incidental benefit.
That's right, but there's just one rider to that. It didn't matter on the particular facts.
Yeah, okay.
We shouldn't get carried away and think that there's an absolute rule here, because clearly there's not. And the court's going to scrutinise very carefully the transaction and the evidence as a whole. But the position was different, wasn't it, with the nomination rather than the extension?
Remember, it cut out Mrs Keenan because she wasn't entitled to it anyway, so they thought to avoid that problem, they'd reflect Mr Giles' intention by being 50% to Mrs Giles and 50% to the son, Nicholas. And like you said, Justice Baskell was conservative in her approach and said, well look, she wasn't, when there was no specific authority for a conflict transaction, wasn't prepared to make that leap for them to go changing that nomination more so in their favour. And that was even though Mrs Keenan had disclaimed her benefit.
But it was hinted in the judgment, although the judgment doesn't go this far, at least the door was left open that it may be possible in some circumstances for somebody acting as attorney to make a nomination. So there's not an absolute bar on it by reason of this judgment.
But that's a really interesting point. I guess, what do you think, Richard, for this example is, let's say there was one of those powers of attorney you talked about with a general authority to authorise any conflict transaction as defined in the Power of Attorney Act. If that was in there, does that therefore mean that when a member's made no nominations before, let's say it's a second wife or something like that, or as, the nomination's lapsed, or there's a nomination in place, can that attorney, let's say the second wife, because it usually is in these death benefit disputes, can that attorney, because they've got that conflict, change or make a new nomination totally in their own favour? Or even though they've got that authority, do you think the court would impose some limits?
We don't know. This is one of the untested areas. This is for another day. But I think what Her Honour pointed out was this, that there may be a difference when you're looking at a special condition and enduring power of attorney that is a general conflict authorisation, as distinct from a very specific authorisation. Because if you built into a power of attorney an authorisation that, for example, specifically allowed an attorney to renew an existing nomination, it's much easier for the court to join the dots and to reach the conclusion that this really is consistent with what the member would have wanted if they had capacity.
So I think, it's important to show that the member actually turned their mind to this specific question and then made informed authority on it, I guess.
There's a big job, isn't there? You're going to have to go through all your powers of attorney now and contact clients.
Yeah, well, we always recommend, Richard, that we do have that specific clause, and our default one is that they can reinstate or renew or confirm nominations but not change or make. So at least we have that conversation. So if the client says, no, we actually want them to be able to change it, well then we put in another clause.
So you've already been drafting that for some time?
Yeah, and so, because it's so important to, I guess, have that conversation with the clients. But it's a pretty scary situation if an attorney can just go and willy-nilly, I guess, change the planning that a member might have already done.
There's a lot here, isn't there? A lot of different issues, and the judgment's not that many pages, but when you start to unpack it, there are a lot of things that flow on from it. There's also another useful angle that follows on in the judgment, and that's the question of a nomination document. Let's say it makes a nomination in favour of 3 or 4 different persons, nominees, and one of them's a person who's not allowed under SIS because they're ineligible, they can't take a benefit. What was the position prior to Narumon on that?
Sorry, Richard, I apologise. I just have one thing come into my head and it's a bit rude. But one more thought I had was, you've been involved, back to the power of attorney issue before we move on and the conflicts, you've been involved in quite a lot of statutory will cases, and in those you were successful in the Court of Appeal case that Merthyr Law instructed you, where a mum who was dying, where the court ordered a testamentary trust be put in place so to ensure that her inheritance avoided going to the in-law, the daughter-in-law, because her son was going through divorce proceedings. And in those statutory will cases, although there's specific provision in the Succession Act for that, it's very important that that there's evidence that in that circumstance the testator would have wanted that change. It'd be interesting to see if that same kind of evidence would be required even in that, where there's an authority for the conflict, to still show that you're acting in the member's interests and not acting outside of the member's interests, because even if you do have a conflict transaction, that might not extend to actually acting in your own benefit and disregarding the member's interests. What do you think about that?
It's an interesting parallel. It wasn't one that arose in Re Narumon, but there's definitely a parallel there, because this is all to do with the protective jurisdiction, as it used to be called. This is people who lack capacity. And of course, that's exactly what statutory wills are about. And the reason that the case you mentioned was successful, the GAU and GAV case, was because the Court of Appeal in Queensland accepted that when the court's weighing up the application of the statutory requirements to make a statutory will, the focus should very much be on the person who lacks capacity, because the court should be determining and acting on what's in their best interests. Now, there is a parallel, isn't there, here, with this kind of investigation that Justice Bosco went through, working out, well, what would this member have wanted if they had capacity? I mean, it's almost impossible. You don't actually know. All you can do is piece together what's likely from the surrounding evidence. And in the statutory will area, it's section 23 of the Act that sets out all of the factual information that must be put before the court. There's no template here in the area of making binding nominations, but really you're looking for anything that gives a clue as to the member's wishes.
Yeah, and so I guess just to reiterate, with this case we had the $3 million pension. That was important that was reversionary, because the nomination didn't affect that, if that was properly a reversionary pension. Then if the nomination or the confirmation of that nomination, the extension of that nomination was affected, that meant that that nomination, it can't be challenged. It's not up to the trustee's discretion. But as I mentioned before, we had that 5% in the nomination, or the extension of the nomination that got upheld, went to a person who was the sister of the member and wasn't a death benefit dependent. So that 5% failed. And so that's interesting, is, with that 5%, what's the situation?
This must happen quite often, because presumably people can start off being eligible at the time a nomination's made, and the circumstances can change. Well, by the time you get to the death of the member, they might not meet the statutory criteria.
One example is, they might be in an interdependency relationship, and they might have gone to pains to, get that documented at the time that they got their estate planning done. But that person might have moved to a nursing home, or might have changed their position, and they might not meet that definition of an interdependency relationship. Another instance might be that the the nominee, the beneficiary of that nomination, has died. And so they can't, benefit from that.
So this was the perfect case to test the issue, wasn't it? Because the court clearly had to make some sort of finding as to what was to happen to that 5%. I guess there could have been two possible findings. It's binary. One finding could be the whole nomination just fails, which would have been fairly disastrous for Mr. Giles. Or the other one is, well, you can rescue the rest of the nomination. But it's not quite that simple, is it? Because you have to look at the terms of the deed.
Yeah, certainly. And like the lawyers, it's always it depends, it depends, it depends. It depends on the terms of that deed, and every case is different. But your best practice, and there's a lot of deeds out there, your best practice is your deed contemplates. If part of that nomination fails, then what happens with that part that fails? And it should say, well, it usually goes back to the trustee's discretion, and so the trustee has discretion as to who to pay that death benefit to. In this case, it wasn't entirely straightforward, like Richard, you said. It could have gone either of those two ways. But this case, the deed was drafted widely enough, really, to suggest, well, Justice Bowskill certainly thought, well, she should take that purposive approach and said, well, just because 5% fails doesn't mean the whole lot fails. But this clause was drafted on pretty kind of wide terms, with respect to that nomination. If the clause was different and the clause had been drafted that a nomination must be to dependents, must meet this definition, it's quite plausible to see, despite Justice Bowskill's interpretation in this specific case, it might go different the next way depending on the terms of that deed. So
do deeds need to be amended?
Look, certainly, with all these cases coming out, deeds need to be revisited, your pension documents need to be revisited, and just to see, look, do they stand up to the test of scrutiny in the latest case? Everyone was checking the deed about trustee of deceased estate after your Munro and Munro. Everyone's checking changes of trustee after Perry and Nicholson. In this case, looking at those death benefit provisions and, going to a good specialist deed provider and having them as tight as possible. And, it's a continual process, getting those deeds in order and making sure that they're right. Which also leads us to, I guess, in several cases now, there's been deeds which seem to refer to that a nomination must be in accordance with the statutory requirements or the relevant requirements. And so there's been judicial consideration on this in a few cases now of whether that means that a nomination has to be in accordance with Regulation 6.17a, which has some specific requirements or not. And what did Her Honour find in this case with respect to that?
Well, there's echoes in the judgment of, if you remember that South Australian case, Payne, which looked at the rest fund in quite some detail, and Justice Ballou there was fairly frank about the fact that the legislation is not well drafted in various respects because it just doesn't quite fit together around 6.17a and exactly when does that apply. We've got clear guidance though from Munro, from what Justice Mullins found in that case, that it's very clear that 6.17a as a matter of principle does not apply to self-managed super funds unless it's imported. So the key here is working out, well, has the wording in the trustee, in the fund deed, actually imported through the back door those requirements of 6.17a? And it's not all of them, is it? It's just subsection 6.
Which is those requirements of lapsing in after 3 years, being witnessed by 2 witnesses, and those requirements. Interestingly, because it doesn't apply to self-managed super funds unless the deed makes it apply, or the nomination says it lapses in 3 years, then you've got to be very careful about the drafting of those clauses. And in Donovan and Donovan, it was another result where His Honour found, well, because in the actual binding nomination clause, they said it had to be in accordance with the statutory requirements. He said, well, it must mean that it's got to be in accordance with that 6.17a. So an interesting distinction there. And I think the lesson is make these clauses as simple as possible, avoid importing statutory requirements, and avoid making them too hard. Richard, I've been involved in lots of deed reviews and lots of cases, and one deed that's a very popular deed provider provides this deed is they actually make you. It looks like all you have to do for a nomination to be binding is sign Schedule 2 in front of 2 adult witnesses and nominate the relevant beneficiaries, and it's right. And a lot of accountants think, okay, well, that's right, as you'd think if that's an annexure to the deed. But then you read the actual provisions and it says, first of all, the trustee has to give a notice to the members with everything the member should reasonably need to consider to help them making this choice of a nomination. And then the trustee's got to show that they've had a meeting and they've accepted this nomination. And yet a lot of deeds say it's got to be served on the trustee. It's almost like some deeds make you pat your tummy and rub your head at the same time if you want this nomination to be effective.
But the shades of this in Perry Nicholson, which was about a different area of trusts, it was around has a power to remove or retire a trustee being properly exercised, and in that case Justice Badis looked very carefully at the express requirements in the deed, because if a power has not been exercised in accordance with the deed, then on the face of it it's an ineffective exercise and there hasn't been a change.
So this is where it's at in these death benefit disputes, is looking at that real granular detail of all of those deed provisions, of the changes of trustee, and if there's any defects in them, that can mean that estate planning that has been put in place is totally ineffective. A lot of people, Richard, they think Munro, one of the most famous cases in the SMSF place, Katz and Grossman, they think it's a case that says your will doesn't dictate what your super is. But it was another case, it was a change of trustee case. Yeah. This is the area where the lawyers are really earning their stripes, and this is the area where a lot of these death benefit disputes are in.
So do you think your role now, Kieran, then, whenever a client comes in, is to look at all their planning holistically? Stop the kids from getting control of the super fund unless that's really what's wanted? I'm first of all on an education battle, trying to educate that a nomination, it's not something you just do with your annual returns and say sign here. It's not something that accountants should be calling binding, because that's legal advice. And you're exactly right, it's not just filling out that form. It's, if you want to do your job properly, it's looking through that whole deed succession. It's looking through who is going to control that fund after the member dies. It's looking at how that nomination might marry up with their other estate planning, and whether it's appropriate to even have one at all. There's some very important considerations there, and if people are concerned about getting the job done properly, well, it's a big job to look through every deed since 2000 and just doing, an estate planning piece. And clients are often fee resistant. But in this case, if they had one of those specialist lawyers, go through and they said, look, I want this to be as watertight as possible, review the deed, review everything, yeah, it would have cost a bit of money in that initial estate planning. But I've heard from some of the advisors of the money that was spent in this case, and it would have been a lot cheaper than having to have the court clarify all of these issues. Don't forget though, some of these issues need to go to the court to be clarified, because in some cases the trustee will just be stuck. So in some cases where there's a doubt, for example, as to whether a power has been validly exercised, thought needs to be given really to whether there should be an application under the Trusts Act, section 96, for trustee advice, or alternatively declaratory relief, which was the route that was taken in this case.
And the problem there is, Richard, is again, people don't want to go, the trustees often don't want to go to court because of the expense, but the trustees got duties, and if they don't go to the court where they're in that position of conflict or doubt, well then they may be in breach of trust, which can also mean, I believe, that all of the legal fees that they incur, and everyone incurs, they might be personally liable for them rather than having that indemnity from the trust. So going to the court gives you a bit more insurance about against doing the wrong thing, I guess. Would you agree?
I don't think there's a general rule that you'd be denied your fees, but Certainly the court's got the power to do that.
There was that case in Worcester and Morris where I think the second wife in that case, she ignored a binding death benefit nomination. Well, no, she actually got advice that it wasn't binding, but it was obviously in her favour, and spent a bunch of money, and she was trying to get that all out of the member's account. And the court in that case said, look, you've acted in breach of trust, and so you're the one who's going to cop all of the fees that have resulted as to your breach of trust. Not that every action, like an exercise of a trustee's discretion in their own favour, isn't a breach of trust if the deed allows it, but certain items such as ignoring a nomination certainly could be. But
something that's commonly ignored deliberately because it's convenient is if there's been a defective change of trustee, technically what's happened in the past is all of those powers haven't been properly exercised. So you might have a whole chain of distributions that have been made, and actually they're all in breach of trust. If they haven't been made by the people who are actually the trustees. Kieran, there's quite a shopping list, as you've seen, of things that need to be sorted out in this case. But it's interesting, isn't it, that the court dealt with it in an efficient manner, and in a manner that certainly wasn't critical of the trustee. Because essentially the trustee was bringing to the court problems that needed the court's assistance to be resolved. Well,
what was interesting, I guess, in this case too, it was great for all of us practitioners to get clarity on all these 6 issues we've discussed today. But what was interesting in this case is, let's say if the pension wasn't a reversionary pension, the nomination wasn't binding, it still wasn't the end of the world for Mrs. Giles to receive those death benefits, because what was left over, that 5%, it was still, she was the sole director of the corporate trustee. The deed allowed, as any good self-managed super fund deed does, her to act in a conflict position. So, providing she considered all of the other, possible beneficiaries, Mr. Giles' kids from a prior relationship, then it doesn't mean that she couldn't have distributed those benefits to herself, because she still controlled that fund.
The procedure's interesting too, because it's very important to make sure you serve everyone with an interest, otherwise the application can't go ahead and be heard. So where you're dealing with a lot of issues of this kind, missing documents, deeds that may be ineffective, potentially ineffective nominations, you have to think through all the permutations of what's the outcome going to be if that's actually the case. Everybody was served that needed to be served in this case, so the application could have been contested by those people. But as it turned out, the only other representation, as you said right at the start, was the litigation guardian on behalf of the minor child, Nicholas. And he did, counsel for Nicholas didn't make any submissions to the court.
Well, his interests probably aligned with his mum's interests, I think, and he was getting, $500,000 as a 16-year-old, so that's not too bad, I guess.
Do you think the implication of Narumon has been understood? Has the penny dropped yet?
I don't think so. I think I was at a self-managed super fund conference last week, and I mentioned this deed ratification as an issue, which hadn't really been brought up yet, and one of the SMSF specialists there said, yeah, Kieran, I think this is one of these cases that's got so many of these points that we've discussed today that we've just got to let it settle, and each one it'll dawn on us the gravity of this decision. Erin, if you could bring up that slide, I'll go through what I think the takeaways from this case should be moving forward.
Can I just share with you something that might amuse you?
Yeah.
Shortly after Munro, I was at a conference and somebody said, oh, you're responsible for that case. So I hope I'm not going to get something similar for Narumon, because of course it's not convenient, all of these outcomes, because they do require work and thought for advisors.
Well, certainly you've worried a lot of us all lawyers with that ratification case. That's really brought that one home to us. So you have a few lawyers, giving you dirty looks and not wanting to talk to you for, having to fix up some deeds for free, I think. But ultimately it's been pretty good. The 3 super fund cases in Queensland, and we have more than our fair share of them. You've always been acting for the successful party, and they got a successful result in this case too. So well done. So I guess, as a takeaway from this case, there's a lot. We talked about those 6 principles, those 6 issues. But I think one of the things is this stuff is so specialised. Trust law is so complicated. Deed changes and ratifications are complicated. All the super decisions, there's a lot of nuance to all of these superannuation decisions. I think don't muck around. If you're concerned where your death benefit is going to end up, use specialist lawyers and take the time to do a proper review. I think, and also I guess in that point is there's a lot of accountants who might be doing binding death benefit nominations and those kind of things. We've just discussed today how complicated this area is and involved, and accountants aren't insured for giving this type of legal advice. So it's a really dangerous area to play in for accountants. Another takeaway, I guess, for everyone here is have a look at the fund. Do you have pension commencement documents? Do they say it's reversionary? It's not enough just that the financial statements indicate that it's reversionary. That's no proof at all. In this case, it was lucky that there was such good contemporary evidence. But if there is missing pension documents, maybe try to rectify that while we still can. Perhaps have a deed of adoption where we say, look, we did do a pension back in this day, we can't find those documents, this is what it was agreed, it was reversionary and it was in accordance with this. At least it's better than not having anything, so you've got some guidance for the court then. I guess your deed defects, so having a look through all of those chain of deeds and seeing if there are any defects and come out with a plan whether they can be remedied.
Do you know, almost the more you look at deeds, the more you can find wrong where there's a chain. A particular problem is these wholesale adoptions of a trust deed, a restatement. Just think about this. You restate your clause that deals with remuneration. You widen it accidentally. Is that a proper exercise of the trustee's power? It favours the trustee.
Yeah,
there can be all sorts of issues.
Haven't got the members' consent necessarily.
Exactly. So there's a lot lurking as regards those chains and amendments.
And it might be sometimes that the deed's beyond repair, so that it's defective and it can't be remedied because the parties have changed or for whatever reason. And it might be that the answer for that is, well, start again, roll over that benefit to a clean skin fund. And it might be a lot cheaper than going to the court to get the court to, make orders whether, the deed's effective or not. It might be a cheaper way. I've also seen there's some cases where the court's ordered, if a deed's been missing, they've said, well, we don't have any evidence that the deed wasn't executed correctly, so the presumption of regularity is that it was. So you can get the court to fill in those gaps, so to speak, but that doesn't work if there's actually evidence the deed was defective. That then the court can't just ignore that what happened in history.
And the general problem you've got often with trust applications is there's often a large class with minors that need representation. That's where the costs get increased.
Yeah, because it's not easy. You can't get instructions from a minor, so it's kind of hard representing minors. So just having a look at that, especially for the lawyers, watch out for these ratifications of deeds. The banks might have to go and look through, their documents for all these limited recourse borrowing arrangements to make sure that they've still got an indemnity from those trust assets, that they were using that right deed, and that the trust was allowed to actually enter into that borrowing transaction under the relevant deed. So, pretty scary area that I think a lot of the banks in the current environment would prefer didn't exist. Really importantly, I think, is having discussions and having bespoke clauses. So not just leaving it up to chance that, oh yeah, an attorney can possibly renew or change a member's binding death benefit nomination. When we're doing this estate planning, have that discussion. What helps those discussions? Having those bespoke clauses, like I discussed earlier, that an attorney can renew a nomination but not change it. Then you have that conversation and you specifically document what it was that the member specifically wanted.
But at the same time, you're going to be careful around general conflict authorisations.
Yeah, look, I mean, it's a dangerous area, as we discussed before. You've got a general conflict authorisation. Does that necessarily mean that an attorney can do what they like in their own favour? I would think not, when it doesn't align with the principles reasonable interest. You
'Cause
know?
it doesn't show that the members thought through this particular transaction and really envisaged that it could be done by the attorney.
Yeah, but I mean that's a dangerous area, and you know we'd await further judicial light on that. Like all these super fund cases, it's given a lot of answers, but it's also raised more questions too. So it doesn't mean it'll necessarily be the last case clarifying this area. Another one is avoiding lapsing nominations, so we don't have to have that issue. Avoid those archaic deed clauses which incorporate 6.17a and incorporate that the trustee's got to be shown to accept the nomination and other quite out there terms. A nomination doesn't even necessarily need to be witnessed to be binding. It just all depends in a self-managed super fund what that deed says. And that brings us to the I guess important takeaway from this is people might come away from this case saying this case is authority that an attorney can renew a nomination but can't change a nomination, and it's not. This is just specifically this deed, this power of attorney, these specific circumstances. It doesn't mean that that's a universal application for future cases. Would you agree?
You're right, but the building blocks are there, aren't they? So the argument can be made, albeit with different facts if necessary, and that's what's important here.
All right, I think, unless you've got anything else to add, Richard?
No, thanks very much for having me.
Thank you for being along, and anyone, if you've got any questions, shoot them through, or otherwise shoot an email to myself, or if you want to ask any questions later, or I always love chatting in this area. Otherwise, I thank everyone so much for joining us, and especially Richard for giving up his time and his insights into this very important and self-managed superannuation case.